As it plays the court, Your Lordship, I still appear for the state with Mr. Marondeze. The accused persons also still appear as before. Your Lordship, yesterday the court had directed of us to meet in order to streamline the plea-taking process. We had a meeting yesterday and this morning as well. And what we have agreed on, Your Lord, since in this matter, they are all in possession of the indictment. They are in possession of the indictment. Yes. And they've read the indictment from what I'm informed. And we are in agreement that the state, when referring to a count, putting the charge to them, the state will refer to the count itself, to the nature of the offense that is involved in that count, and the accused persons who are involved in that count. And then we request from the accused person to indicate to the court if they've, in actual fact, read the content of, if they've read the content of the count, and if they understand the charge. And then thereafter, they'll indicate the nature of their plea, Your Lordship.
In other words, you are saying you have agreed not to go through the particulars of the offense.
Yes, Your Lordship. They'll just confirm on record that they themselves have gone through the particulars and if they understood the particulars.
I think that is in order. The pace at which proceedings go are not entirely determined by the court. They are determined by the conduct of the parties as well. So if proceedings can be curtailed in any way, that is in the interest of both the court and the parties. Right, so we'll proceed with count 10, isn't it?
Your Lordship, if the accused persons, we just request for the accused person just to confirm my submissions so that we do not have any disputes in the future.
They can confirm. I thought if confirmation can come in the form of silence, but if you wish to confirm, yes.
As it pleases the court.
Any of you want to confirm?
Yes. Good morning, Judge. I would like to confirm that indeed we had the discussion and continued today as well. We've agreed, as stated by the state, that the state will read out the charge, what it is and to whom it relates, and then that the court can then ask if the accused in question has read the charge, understands the charge, and how the accused will plead to that charge.
Yes.
We, as I explained to the state, that we do so but without abandoning the claim we make that an irregularity has occurred. And I informed the state that in fact, the moment that I had indicated that there was an irregularity, I should have made an application in terms of section 317 of the CPA for that irregularity to be recorded. I also indicated to the state, as I now do to the court, that when I made the commitment, which commitment I will live up to, based on the principle that I believe that the irregularity occurred, that I will review the occurrences of the day before, I ought to have taken to mind the fact that the review record would need to be availed to that court reviewing the events that occurred in this court the day before yesterday, that's the 11th. And that the availing of that record is beyond my control and lies in the hands of the court recorders or the stenographers or whatever they're titled, and that would happen only then, so that the commitment I made to say specifically by Friday I'll do that, I cannot in honesty live up to it, but it will be made. Inform the court. On our part, to curtail the proceedings, we'll do that, although we maintain our position, but that we will bring an application in terms of Mwilima for legal representation, which application will affect the dates which were made by the court, specifically the date of 4 February will be untenable to continue, and it is a date. Perhaps I didn't read it properly.
Yes. Anyway, carry on.
So that will mean that in that application, in my improper reading of the court order, would then request for a stay until that matter is determined. But if I have read it improperly and the court then would not proceed in the fashion that it has taken, then that wouldn't be the case. I had then, on that basis, which now seems to be improper, but not necessarily improper, it is a position taken by the court, brought, and I've given the state a copy of the Supreme Court judgment in Hans Friedrich Hashagen and Public Accountants and Public Auditors Board. It's a judgment of 2021, 5 August 2021.
What is supposed to, what point are you trying to make?
The point is in paragraph 35, where it says that it lies ill in the mouth of the maker of the decision to say, let us go through the motions, and you will have the opportunity after we have completed the process to go to the court and have it set aside. That is the general attitude that the court is
on the same point, isn't it?
Excuse me, Judge?
You are still on the same point about the irregularity.
Yes, I'm just explaining to the court.
Yes. That's why I'm asking. Are you still around the same point of an irregularity having occurred?
Yes.
Yeah, but I have said that we proceed.
Yes.
So,
Hence,
I can't revisit that.
no.
What do you want me to do now?
I now apply, in terms of Section 317, for that irregularity to be recorded. And I've just given you the motivation for that application. And whether you grant it or not, it's not the issue. It's just that, in the abundance of caution, I do not want it to be raised by the state or the court that, but you proceeded on with the irregularity, yet you say it's an irregularity. I raise that irregularity now, and I want it recorded as such, and I am unable to proceed with that application before the record is transmitted. Otherwise, I would have done it today, for instance, but the record is not yet transmitted. And
sorry, Mr. Shanghala. Yes. Are you making an application, or you want to make that application?
When I began, I was confirming the discussion.
No, that's all right.
Yes.
I'm asking a question. Are you making an application, or you want to make that application later?
I made the application.
You are making it now?
Yes, I'm in the thrust of the application.
Right.
Yes.
So your application is in terms of Section 317.
That an irregularity has occurred, and that it be recorded as such for determination. And that notwithstanding that we will proceed.
Just a minute. I don't recall what Section 317 says.
Oh, yes. It provides that when an accused believes, or the state believes an irregularity has occurred.
Just a minute. 317 of the CPE.
CPA, yeah. The request is that a special entry be made in terms of 317 relating to the irregularity which I allege has occurred. And that irregularity I allege has occurred is that the court continued, notwithstanding that the jurisdiction under 106(1)(f) was raised. I allege that the correct procedure should have been that the court would have had to determine the jurisdiction as a peremptory step before it proceeds. Authority for this, I will give the court a copy again of that judgment as well, is Xolani Teddy Sidu versus the state in the Mpumalanga Divisional Bombela Division Court. It's a judgment of 2023, November 8.
Yes.
So I base my application on authority, and part of that authority, one of the cases is Xolani Sidu, S-I-D-U, versus the state. It was in the High Court of South Africa, Mpumalanga Division. The case was determined on the 8th of November 2023 by a bench of 2 judges, full bench, if I may. And this court is authority for the proposition that once a plea of 106(1)(f) is tendered, it is peremptory, and that the court has to determine first that plea, and that is apparently also in connection with section, just need to look at the, (108) of the CPA, which reads that if an accused pleads a plea other than a plea of guilty, he shall, subject to the provisions 115, 122, 141, by such plea be deemed to demand that the issues raised by the plea. That didn't happen. And how it should happen is that the onus is on the state. And the onus is as a standard of proof of beyond a reasonable doubt. In paragraph 10 of Sidu, there's a sentence there which I'd like to read into the record. It says, whilst the prosecution was still weighing its options as to what to do, the court acquo, despite a concern raised by the state, interrupted and raised its concerns regarding the delay of the matter, and thereafter summarily ruled that the trial should proceed. This is exactly on all fours with what has happened, perhaps not 100%, but the principle that you can extract from there. And then at paragraph 13, it is evident from the record that the court acquo was not sure of whether the court had jurisdiction or not, hence its failure to make a ruling on the issue. The court acquo erred in this regard. It was, so it seems, in a haste to finalize the matter. And in this case, the judge rightly said that that court is the High Court in which the matter is pending in the reference number HCMD CIV motion review 2024-00574. That is the court that is dealing with that matter and refused to determine this matter. And then, at paragraph 15, section 108 requires that evidence be placed before the court to establish the issue of jurisdiction or lack thereof. By failing to allow the parties to lead evidence, the court Akwa denied itself the benefit of evidence from either party. The court Akwa, therefore, had no basis upon which it could decide whether or not the court had jurisdiction. This was another material misdirection on the part of the court Akwa, as the court Akwa was enjoined to make an informed ruling on the special plea before proceeding on merits. It is trite that if a court has no jurisdiction, a judgment entered therein does not adjudicate anything. A court does not have the power to extend or assume jurisdiction over matters beyond the scope of the authority granted to it by its creators. And then at paragraph 18, the conduct of proceedings aforesaid in relation to the issue of jurisdiction is a procedural irregularity which rendered the trial unfair. So that is the basis upon which I bring the application, and may I request the police officers to just avail the judgments to the court. The court orderly is not here. Thus, I apply that the section 317B special entry be noted, and that
What is the court empowered to do in terms of 317?
the court can either reject or grant the special entry. In granting the special entry, I believe that the law is similar to the provisions of 319, is that it is the court that frames the question.
The cases you have referred to, was the issue of jurisdiction before another court?
No.
So, do you not find that to be a distinguishing feature?
What I believe is, when the plea of
No, we
jurisdiction...
don't believe here. Here we submit. In church we believe.
Amen to that. My apologies, Judge. What I submit to you, Judge, is that in your judgment on the matter that I had brought ex parte 319, along with the other applicants, you indicated therein, and I will give you the paragraph shortly, that the matter of jurisdiction, the matter which we raise, one of the questions we raise, engages the jurisdiction of the court. In your judgment, in the consideration of the 149 in the point in limine, you said that it must be raised initio litis. We are at initio litis. I'm raising it because...
Yeah, but the important point for me, first, did you agree with the other side that you will be making this application?
Which other side?
The prosecution.
No, they didn't need to agree. It is
No,
my
I'm
prerogative.
not saying they needed to agree. You were in consultation
I just informed.
about plea taking.
Yes, Judge.
I'm saying, were you courteous enough to say to your colleagues on the other side, well, guys, I will start off again making another application?
No, what indeed I told them that I am going to make an application that a special entry be made, and I also
All right,
gave them
if
the
you told
reasons.
them, that's fine.
And the reasons are similar to the one that I gave, that ex abundanti cautela, in the abundance of caution. I do not want the state, because it's a big institution, maybe some other prosecutors will rock up in the review in the Supreme Court and say, but you went ahead with the reading of the plea when you say now in the Supreme Court that you are reviewing an irregularity. I am saying, because the court has made a ruling and the court will continue, I'm not challenging that.
So
I don't
want
have
that issue to go to the Supreme Court in two ways.
Which one?
The issue about jurisdiction. You want it to go to the Supreme Court in two ways.
No, what I'm asking the court, what I intend to ask the court in the review is specifically that it was an irregularity that the judge shouldn't have proceeded, should have put the onus on the state to prove the jurisdiction, and because of the special circumstances of this case, the judge ought to probably have exercised judicial deference to the other court to then...
In that review application, you want the court, the Supreme Court, to declare that an irregularity has occurred.
And therefore...
And therefore it must be set aside.
Correct.
In the 317 application, what do you want to achieve?
In the 317 application, I simply seek that a special entry be entered.
For what purpose?
For the purposes, and it can be determined at the end of the trial. It doesn't need...
For what purpose?
For the purposes of recording the irregularity that occurred. As an abundance, in fact, the very fact that you will turn down this 317.
You know I will turn down.
Yes.
You already know.
I have not gained anything that I've raised here from you whatsoever.
Shanghala,
I am therefore
if
convinced.
you make a good point, this court will grant you. If you make a point I don't agree with, I will not grant you. It's as simple as that. It's not a question of me favoring you on this one. You have made 5 applications. Now I think the 3rd I must grant it, or the 4th I must grant it. I will grant an application if I think it is merited. It's no use telling the court before which you are trying to persuade to take a view to say, I know you are going to reject it. I mean, it's your way of dealing with matters, but I don't think it's very helpful. When you make your application, just be bona fide about it. Just be honest about it and say, look, this is my application. The court will consider. If you start off by saying, I know you will reject it, so why are you making it?
You know, Judge,
are you making just to make a point or what?
Well, Judge, you see, I have previously in this court invoked the discipline of statistics and how anomalies are the norm in this case. And I have relied on Supreme Court justice judgments.
Not all anomalies. Things don't happen very, very smoothly all along. This is a big trial. So many things are raised, especially by yourself. We deal with them. It's not a question of saying to the court, I know you will reject it. So why are you making it to me? But my question is this one. As I said, the ultimate objective of your 317 application is to get the Superior Court to do what?
Eventually, when it reaches the Supreme Court, to determine that there was an irregularity. But why I raise it now?
Right, let me step by step. In the review application, which you will file by Friday, you want the Supreme Court or the Supreme Court to declare what has occurred an irregularity. And you want to take 2 routes. One application under 317 for a declaration that there has been an irregularity. Another application by way of review for a declaration that there has been an irregularity. That's what you intend to do. No,
my understanding is that you have ruled already in respect of the 319 for sure clearly that in Namibia 319 can only come after, okay? And my understanding is 317.
No, it's not me alone, the Supreme Court as well.
Yes, this is the most recent judgment that I'm aware of. There may be another one.
No, I'm saying the Supreme Court confirmed that.
In which judgment?
What judgment? The Supreme Court dismissed your petition.
Oh yes, it dismissed
that means
it.
They confirmed what I said.
Oh yes, that is the view that you've held all along. I hold the view that the most recent judgment is the judgment of this court in my ex parte application of 319. Now the 317, my understanding is that it is not necessarily an issue that can be remitted to the Supreme Court or transmitted to the Supreme Court immediately.
The issue of the irregularity, are you satisfied that when you file your review application, that issue, whether an irregularity has occurred or not, will be resolved?
Am I, so
are you satisfied or not satisfied that when you make your review application, the issue of any irregularity which has occurred will be resolved by the court?
Yes, I'm only hopeful, and my belief in the system.
You hope for that?
Yes, I hope for that.
And then you hope that if you go by way of 317 again, a kind of parallel approach, the result will be the same.
No, you see, this is what I was saying. First of all, I won't be there on Friday. I can't, because I must wait for the record to be transcribed. That will probably be affected by the fact that it is a festive season, one. Two, my understanding is that 317 isn't automatically transmitted to the Supreme Court. My understanding is that that waits until the end. I may be wrong,
no,
but
I'm just wondering which route you want to take. If you are taking parallel routes, you are taking both routes, you just say it.
no, it's not the issue. That wasn't my main concern. My main concern was, and I stated it, I do not want the state to then appear in the Supreme Court and say, why then did you agree to continue with the reading out of the plea when you state that there is an irregularity?
The state can't say that, because it is common cause that it is the court which ruled that we continue.
Yeah, well, then, you see, that already, this exchange, and if that is the ruling, is exactly what I would require. That shows beyond reasonable doubt, and that court, because that court is known to make extrapolations of A, B, C, Ds in the theoretical abstraction about this case, even when the state doesn't raise it. I want to make sure that that case when it reaches there, doesn't become fertile ground for such extrapolations like the ones that Judge Frank made when we last were before him. I'm just being cautious.
I don't know what Judge Frank said.
Yeah, well, that's another issue, but he will know. They will know that what we are talking about.
To me,
Yeah.
for it to be relevant, whatever Judge Frank said, go to tell me what he said.
No, what he said was he took the point we raised in our bail and he created a theoretical extrapolation of, but if X happens, don't tell me that this can't happen. Surely this could happen. And that related to the point we raised during our bail. Not relevant now. That will be an issue raised in the court in the fullness of time. As you remember, you had already said that when we have pleaded, interlocutors will be brought. We had raised an issue. But this is just in the abundance of caution. If the court turns it down, I'm happy to record it. If the court grants it,
Mr. Shanghala, do you agree with me that insofar as the issue of jurisdiction based on my appointment is concerned, I have said that we wait for the determination of the application you lodged?
Yes.
And I'm agree with that.
Yes.
And in the meantime, what did I say?
You say
we'll
proceed. We'll proceed.
Yes. And then you said you file a review application. I said, well and file.
Yes.
And I said, in the meantime, what? We proceed.
Yes.
And I asked you and the other side to see how we can curtail these proceedings. If this is part of the agreement to speed up the proceedings, I'm not impressed.
No, I'm saying that we speed up because I'm under duress. I'm not doing it willingly. I'm still asserting the issue of the irregularity, and that I'm now.
I will not rule on the same point 3-4 times.
Yeah. And I'm saying that that is wrong to say that you cannot.
Yes, you can proceed. Do you have anything else to say?
Just to mention that the paragraph that I was referring to of your judgment, or the judgment that you rendered on the 18th of November 2024 in respect of the point in limine, the 149, is paragraph 34. That's where you...
Mr. Shanghala, when you make your submissions, you rarely, if ever, hear me say to you, you are wrong. You have this habit of saying to the court, you are wrong. These things are debated, and a better view will carry the day. I don't think it's proper language for you to frequently say to the court, you are wrong, and you are right. Even when I think I'm right, I never say to you, you are wrong. Because I will consider an argument, I will consider a position placed before me by a party. If I started off by saying you are wrong, I don't want to hear you are wrong, would we proceed?
I stand corrected then.
Yeah, I'm saying your duty, if you want things done properly, your duty is to persuade this court that, Judge, look, I've got this view, this is what I'm submitting, can I have a ruling on it? If you start off by saying you are wrong, Well, I don't know who you will find who is correct.
I stand corrected, Judge. I also hope that the judge has recorded that I've been recording that I've been unsuccessful in any application.
It doesn't matter. You can apply 100 times. If you are not making a good point, you will not succeed. If you apply once and you are making a good point, you will succeed.
Yeah, and I'm saying that that just doesn't apply to me. It applies to all the lawyers. That, you remember I named their names, the senior counsel.
You go to the Supreme
They are all wrong.
Yes, you go to the Supreme Court.
Yeah, and these ones have always been correct before the court. In this case, I find that an anomaly. But as it pleases the court, my application is made.
Yes, Mr. Lutwezi.
As it pleases the court, Your Lordship, I think maybe just a few minutes before.
Can you speak loudly, please?
As it pleases the court, a few minutes before the matter started, we were informed that he intends to bring this application. But in any event, the state will respond to what the applicant has brought before court. First and foremost, when bringing an application of this nature, in terms of Section 317 of the Criminal Procedure Act, the application itself must be bona fide. It should not be frivolous or absurd. By frivolous, it has been interpreted to mean it should not lack seriousness. And that it should not be an abuse of process. Those are some of the requirements in terms of Section 317. Now, what we have here before the court, the applicant has himself also indicated to the court that once he brings this application, and the court has to determine it, after conviction, that is when the matter will be dealt with. And he's also indicated to this honorable court that he intends to bring an application on the same grounds to the Supreme Court within this month to review this court's decision. So the application which he intends to bring to the Supreme Court, that will most likely, in all likelihood, in actual fact, be disposed of sooner than this application which has been brought today before this court. So at the end of the day, Your Lordship, if he is serious about moving such an application to review the court's decision, and he wants it to be disposed of quickly, that will be disposed of quickly by the Supreme Court. The second point I want to raise, Your Lordship, when this special plea was raised by the applicant, I recall the court had inquired of him that what does he want the court to do with regard to the special plea, because it involved the appointment of the judge. And I recall the applicant had informed the court at that stage something along the lines that he did not require a ruling from the court, because then the court will be ruling in its own case involving its own appointment, and that is a matter which is already pending before another court. So what does he expect from the court? What are his factual findings that there is an irregularity which has been committed by the court when he himself is informing the court that, look, I do not require a ruling on this particular application. Let this application be dealt with by another court. And in actual fact, this is a living issue which is for another court. Your Lordship, I respectfully submit that insofar as this application is concerned, it's not a bona fide application before this honorable court, and it is an abuse of process. On that basis, Your Lordship, I respectfully submit that there is no need for a special entry to be recorded in respect of this particular case. That will be all for the state submissions, Your Lordship, unless there's anything else that
I just want clarity. The application in which he and the others are suing the president is concerned with what? The jurisdiction issue, isn't it?
Yes, Your Lordship.
And the application he wants to lodge on Friday is concerned with the jurisdiction issue.
Yes, Your Lordship.
And the stay of proceedings is concerned with the jurisdiction issue.
Yes, Your Lordship.
And the 317 is concerned with the jurisdiction issue.
Yes, Your Lordship. On that basis, it's the same application before separate courts. That's why I say that there is a lack of bona fide application in this particular case, and it's an abuse of court process at the end of the day, because this issue will be dealt with by the other courts, Your Lordship, as it plays the court.
Yes, any response?
Yes, Judge, I should have actually commenced by addressing those points that are contained in 317. The issue of the bona fide, whether or not it is bona fide, whether it is frivolous, or whether it is absurd or it's an abuse of process. Nonetheless, the answer has dealt with them, and I have the following to say to that. The issue of the jurisdiction is not frivolous. A court has determined that there are merits in the application and has granted me permission to bring the application. Namibia, Botswana, and South Africa are the only 3 countries in the world that we know of which require permission to be granted to sue a judge in his name. No other country has it. Not the Commonwealth, not civil countries. But the requirement is that to avoid unmeritorious and frivolous claims, you are granted permission by application to cite a judge. So that court has exercised its function, that judgment is extant. On that basis, the case I have referenced is filed. As regarding the issue of whether or not it is, so it's not frivolous and it's bona fide. And the bona fide is based on what I said before, the principle, I believe in the principle of a fair trial, which implies that the trial inter alia must have been by an independent, impartial, and competent court in terms of Article 12, 1A of the Namibian Constitution. Now, on the issue of whether or not it is an abuse of process or absurd, what I said ought to have happened is, the irregularity is that once the plea is raised, and I say I raised the plea because of the principle, once the plea is raised, the court shouldn't continue. And the judge has rightly conceded that it wouldn't be proper for this court to deal with that issue. It is being dealt with by another court. Now, what the court would have done is to say, I'm exercising judicial deference, I'll wait until that matter is determined. Had that happened,
That is what I should have done.
That is what I believe ought to have occurred and what the court should have done, based on the cases that I have given you. That Munuma and those 2 cases, that would have meant that this application would not have arisen. And I say that I brought this application because I realized that once I raised the issue of an irregularity, and that irregularity is the continuation, not that the judge is continuing to hear, that is another matter, but the continuation after the plea has been raised, that irregularity of continuing once the plea had been raised, that should be a special entry. So what I'm seeking to have raised as a special entry is not that the court has no jurisdiction. It is that once the plea had been raised, the court continued. The court failed to put the onus on the state, etc. By necessary implication, a mental thinking, well, mind is thinking, but an exercise of analysis would have brought the parties to the conclusion that, however, if the court is then to get into this matter and hear it, it should have done exactly what I said previously, is to say, I can't determine my matter, I will defer to the other court. But that's not what the court did. The court then went on and said, through its directions, that we are continuing to these dates until the 20th, and then we commence on the 4th, according to whatever reading is proper that one gives the directives. And this is the assertion of the right to a fair trial by an independent, impartial, and competent court, something which the rules of ethical conduct of Judicial Conduct in Namibia underscore. And that is really the reason why, and I'm saying with the cases that I've given you today, Tidu and Olani Tidu, I think, Sidu, Olani Sidu, and with the case that the other case that I gave you, is to say that you cannot just say we can proceed because it's being dealt with by another court, and that's the irregularity that I seek to be recorded. Unfortunately, the circuitousness of the proceedings has been brought by the fact that I was just trying to assert my rights and not being properly represented. And I have not practiced as a criminal lawyer in the courts. My work has been advisory, legal drafting, commercial issues, not these issues. So I am at a disadvantage even though I am legally trained. And seeing yesterday what happened, the interaction between Mr. Gustavo and the court, I realized that maybe more damage will be done if we continue with this irregularity. Lastly, Judge, there's a point I wanted to raise lastly.
Just throw in things. What happened, which informed you in my discussion with Mr. Gustavo?
Mr. Gustavo, being a layman, raises a concern about the tax information, something which has taken, for example, the Constitutional Court of South Africa to determine, not once but twice, more recently, saying that the public interest must be struck.
Didn't you reach an agreement on that?
Yeah, well, yes.
Because I don't necessarily agree, but if it is by consent, I have no problem with it.
Yes, another issue may happen, may arise.
No, let's deal with issues when they arise.
See, well, it cuts contrary to human nature. Human nature, you experience and you adjust your forward expectations based on that experience. You don't just, otherwise, to do the same thing repeatedly is absurdity, isn't it? But anyway, there's the last issue I wanted to raise.
Is that in reply or what?
That was my reply, Judge. I think I've covered, that's my reply, Judge. Thank you.
Right. Just a minute. Yes.
Judge, I apply leave to just make the concluding remark in my, I apply for leave to make a concluding remark that I had forgotten. I'd like to make a concluding remark that I had forgotten. Once the court had asked me that question, my train of thought sort of abandoned me. It has returned. I'd just like to make that
Which
point.
question was that?
The question you had asked me. Now I even forgot.
But you are saying
The
your
judge
mind
said,
left you when I asked you a question.
Yes.
Which question was that?
you said, let me interpose something or let me interrupt something. That's what you had said, and then I responded to you. But before that, I wanted to make a point, and then that point has returned to me now. And I'm asking leave if I may make that point now.
Yeah.
That point was, Judge.
Wait. You're asking for permission and you want to proceed before you're given the permission.
Oh no, I thought when you said yeah, I thought it was, my apologies, Judge, my apologies.
Right. Proceedings in court are handled in this way. The applicant makes his case, right? The respondent replies. The answers, makes his submissions. And then the applicant replies, dealing with points raised by the respondent. It's not a question of every time I'm starting again, I want to make this thing and so on. You can see how much patience I exercise in allowing you to just stand up and make an addition and so on. But I want to remind you that proceedings are, the one party makes its case, the other one replies, and then you have the final right of reply. Otherwise, we go on and on. So, for today, only Mr. Esau will understand. I forgot to take my high blood pressure tablets. I don't want to appear like I'm losing it. But the whole point is, that is how we proceed. I will allow you to raise whatever point you want. But please don't get into that habit. You have one chance to make your whole case, and then the other side replies, and then you have a final opportunity to reply, and that's the end of the story.
I'm much indebted to the court. Thank you very much, Judge.
By the time you leave this court, you'll be a legal practitioner of some note.
Thank you, Judge. Judge, it is relating to the issue of when I will make the application for review.
I don't go back. You told us you are going to make it. If you have difficulties, you will cross that bridge when we said you will do it by Friday next week.
No, what I indicated to the state and what I indicated to the court was that I was wrong. I hope I can say I was wrong. I was wrong to make that commitment because I had not taken to mind the fact that I would require the review proceedings to be transcribed and availed. And that is all that I wanted to make, Judge. That as soon as that is available, I will file that application. I'll complete it next week.
Remember, that's why I always say I can be detained by applications which a person intends to make at a future date, because I never know what will happen. The person must make his application. If you intend to make an application, we wait until you make it. Otherwise, so many things can happen. You can even say, come Friday, say, I changed my mind, I'm no longer making that application. So that is why I'm saying I'm not going to be detained by intimations that I want to do that or that. Just do what you must do. Right, when you do that, we come to deal with it.
Right, so
and the other point, Mr. Shanghala, I don't know whether it is necessary for me to say so. I am sworn to administer justice without fear or favor, without ill will or affection, and that is what I will do. Right.
Thank
you. During the course of plea taking, this is my ruling. Mr. Shanghala made another application. In terms of Section 317 of the CPA, for a special entry to be made with regard to what he perceives are irregularities occurring in relation to continued plea taking. A special entry is made in terms of 317. If the court is satisfied that the application therefore is bona fide, is not frivolous, is not absurd, and is not an abuse of the court process. The issue of jurisdiction, which is at the heart of a number of applications that Mr. Shanghala and his colleagues have made, is the appointment, the validity of the appointment of the presiding judge. Now, the applicant has raised it and intends to raise it by way of application. He has filed an application citing the state president and others concerning the validity of the appointment of the presiding judge. And that case is pending before the High Court. Only yesterday, he applied for a postponement, which I dismissed, also around the issue of jurisdiction. He had earlier made an application under Section 319 for the issue to be referred to the Supreme Court. I dismissed that application, and when he petitioned the Supreme Court, it dismissed that petition. He has indicated that he intends to file a review application to the Supreme Court concerning the issue of jurisdiction. He has indicated that he wants to make an application to me for the stay of plea proceedings. Now, it's all about the appointment of the judge. I have ruled that the plea taking will proceed despite all these applications, and that when the court determines that the judge's appointment is unconstitutional, then the proceedings before me will cease. And until then, we will proceed with the plea taking and with the trial to the extent that we can do so. Now, with all these applications, and the last ruling I made that we will proceed and deal with the plea applications, that decision stands. It has not been appealed against. That decision stands. Now, the present application, in view of all these applications and all these attempts to forestall the progress of the case, is, in my view, an abuse of process, of court process. And for that reason, that application under Section 317 is dismissed.
The court, Your Lordship.
I will not be, I have warned in the past that when it comes to certain kind of applications, this court might consider having to mulch a part with costs if it is of the opinion that it has become an abuse of process. We have to deal with a case, with all our cases in good faith. We have to deal with cases regularly, procedurally. And matters that are before other courts for determination must be determined. And I have urged the parties to approach those courts and urge them to deal with those matters as matters of agency There's nothing that stops a party going back to court and say, this is a matter of urgent. See, the judge is continuing to take pleas from us when we think it's not right, and persuade that court that matter must be dealt with, even before Christmas. Courts have been known to sit on urgent applications all the time. That is part of my ruling. We'll proceed with plea taking.
As it plays the court, Your Lordship. Your Lordship, may I just request for a short adjournment, 10 minutes adjournment, a health break.
Yeah. You see, I will refuse a health break if you carry on in this fashion. People must, this is not a child's play. We are busy here. The court will adjourn for 10 minutes. Yes, Mr. Lutwezi.
As it was a court, Your Lordship, the state is ready to continue putting the charges to the accused person as agreed upon. Count 10, they are charged with the crime of fraud, tax evasion, as read with the provisions of the Criminal Procedure Act, sections 94, 155, 156. This is in respect of accused 1 to 6. Your Lordship, the state requests for the accused persons to confirm that they have read and understood the content of count 10.
Yes, Mr. Gustavo.
Lord, I've read the contents of count 10. I understand them. I'm unable to plead, my Lord, as I've now continued with that as I said yesterday.
And for your entity as well.
That's for my entity as well, yes. No, sorry, there's no entity. There's no entity here.
There's no entity there, yes.
Myself.
Inability to plead is still the same basis that you have no legal representation.
That's correct, my Lord.
Yes, I enter a plea of not guilty.
Yes, I plea in terms of section 1061F that the court lacks jurisdiction.
I enter a plea of not guilty.
I plead.
Please confirm that you understand the charge.
Yes, Judge.
Yes. Yes.
I've read the charge. There are issues with the charge which I reserve my right to challenge later. I plea the plea of section 1061F.
You understand the charge.
Yes, I understand, and I reserve the right to challenge it later.
A plea of guilty, of not guilty, or a plea which is not one of guilty, means that you are placing the issue in dispute. If you enter a plea other than a plea of guilt, you are placing the issue in dispute between the parties. So you understand the charge, and you raise your usual plea.
Yes, Judge. That is also to the alternative. Okay, the alternative is coming.
A little concern I have about this procedure. This is a public hearing, isn't it?
Yes, Your Lordship.
How does the public get to know what the charges are?
I think it will depend on the preference of the court. If
No, not so much. I'm just thinking, you know, it's a public hearing. People are sitting here. They want to know what the charges are, what the parties are saying. The press is here. Unless you provide them with the particulars, so that otherwise the nature of a public hearing becomes a little detracted from But anyway,
As it plays the court.
we will proceed as agreed.
As it plays the court, Your Lordship.
But it was just a concern I have that in a public hearing, those who come to court, the public, would want to hear what the case is all about.
As it plays the court.
You may.
The indictment is also a public document.
The indictment is a public document.
Yes, we don't have any issue with them having access to the indictment if they need more details regarding the charges. But I'll refer to what offense it is that they are charged with.
Okay.
But as it plays the court.
All right, in respect of Mr. Shanghala, I have entered a plea of not guilty. Yes? Is our yes?
A very good morning, Your Lordship. I was provided with this very indictment, count 10. I have read this count, this charge, as amended. And I am taking cognizance of the fact of section 12(1)(e) of our supreme law, the Constitution of the Republic. I don't have any legal representation, and I'm pleading not guilty in the absence.
Sorry?
I'm pleading not guilty in the absence of a legal representation.
Yes, I enter a plea of not guilty. Otherwise, I look for to call upon the next. If you know the sequence, would the next one please just stand up? Otherwise, I have to look at my documents to see who is the next one. James, Tamson.
Yes, my Lord. I understand the charge. I'm pleading not guilty.
Yes, I will enter a plea of not guilty. Yes?
Yes, Judge, I understand the charge. I plea in terms of section 106, 1F of the CPA, and that is to say this court has no jurisdiction.
Yes, I enter a plea of not guilty.
As it plays the court. On the alternative to count 10 at page 79 of the indictment, this is a charge of failure to furnish tax returns for tax. That the accused are guilty of the crime of contravening section 65, subsection 1A, read with the provisions of sections 12(1), 15, subsection 1, 25A, 55, 56, 59, 60, 69, 66, 83, 87, 96 of the Income Tax Act 24 of 1981 is amended, and sections 94 of the Criminal Procedure Act 51 of 1977 is amended. Failure to furnish returns for tax in respect of the same accused persons in the main count, Your Lordship, 1 to 6.
That one is short. You might just as well read it.
As it plays the court, Your Lordship.
It is short. You might just as well read it.
As it plays the court. In that from a date more precisely unknown to the prosecution, but before and including the 7th of August 2014 and continuing thereafter at or near Windhoek in the district of Windhoek, the accused persons individually failed to submit their tax returns reflecting their correct gross income for the tax periods 2014, 2015, 2016, 2017, 2018, and 2019.
Yes,
accused 1. The alternative to count 10. Again, I'm unable to plead, my lord, due to lack of legal representation. I do understand the count. I've read it. I do understand it.
Yes, I had a plea of not guilty.
I've read the alternative to count 10. I understand the charge. I plead that in terms of section 1061F, the CPA 1977, that the court has got no jurisdiction.
Yes.
I too have read the alternative count to 10. I understand it. I plea 1061F. I plea under that section.
Yes, I enter a plea of not guilty. Yes, Mr. Esau.
My lord, I have also read the account, the alternative to count 10, and I understand it from the face value as it is, and I am pleading in the absence of a legal representative, not guilty. Not guilty.
Yes.
My lord, I understand the charge. I'm pleading not guilty.
Yes, not guilty plea entered.
Yes, I understand the count, Judge, and I plea in terms of section 106, 1F. There is no jurisdiction.
Yes.
As it pleases the court, count 11, that the accused are guilty of the crime of contravening section 18 subsection 2A of the Righteous Assemblies Act 17 of 1956, conspiracy to commit fraud, tax evasion, read with section 84 subsection 2, 92, 94, 155, 156, 332 subsection 5 of the Criminal Procedure Act 51 of 1977. This is in respect of accused 1 to 5 and 11 to 22. Should I read this into the record, Your Lordship?
Well, that is a paragraph you always...
I can proceed.
Yes.
In that, from a date more precisely unknown to the prosecution, but before and including the 8th of December 2011, and continuing thereafter to 27 November 2019, and subsequently thereafter, and at or near Windhoek in the district of Windhoek, and or elsewhere in Namibia and or elsewhere outside Namibia. Accused persons 1 to 5 and 11 to 22, together with the Samherji group of companies and its representatives, and acting in common purpose, did conspire with each other and or with one or more of them to evade paying income tax for the 11th accused as described in count 9 above, by agreeing to pay part of the accused 11th's earnings from the sale of fish quotas to the Samherji group of companies and its aforementioned subsidiaries in an offshore account opened in Dubai for that purpose.
Thus the accused persons contravened
As it pleases the court, Your Lordship. Thus, the accused persons contravened Section 18, subsection 2A of the Regional Assemblies Act 17 of 1956, as read with Section 84, subsection 2, 92, 94, 155, 156, and 332, subsection 5 of the Criminal Procedure Act 51 of 1977.
Yes, Mr. Gustavo.
My Lord, I understand the count. Perhaps just on behalf of myself, accused 1, and also in respect of the entity accused 11. I understand the count. I'm unable to plead in the absence of legal representation.
This not guilty plea is entered. In this respect, perhaps I just need to highlight to the accused that for as long as you have no lawyer, isn't it? You are in court representing yourself. If you have no lawyer, you are in court representing yourself. You may wish to say, I have no lawyer, but I know because you don't have one. So the question is simply, what is your plea to the judge? You know you don't have legal representation, so you may repeat it as often as possible, but I know that you don't have a lawyer. All you need to do is to plead. If you are pleading, if you are not pleading, you act accordingly. Yes, Mr. Hatuikulipi.
Yes, in respect of myself, accused 17, 18, 19, 20, and 22nd, we plead in terms of section 1061F of the CPA 1977 that the court has got no jurisdiction.
Yes, and I plea of not guilty. Mr. Shanghala?
I've read the charge, the count, I understand it, and I plea in terms of section 1061F. The court lacks jurisdiction. On behalf of myself and accused 21.
Yes, I enter a plea of not guilty.
My Lord, count 11. As a layman, I read this very count. And I understand it from the face value as it was put to me. And I don't want to repeat that 12(1)(e), but it is a fact. And I'm pleading not guilty.
Yes, I enter a plea of not guilty.
My Lord, I understand the charge. I'm pleading not guilty on behalf of my entity, 12, 13, and 14.
Yes.
On behalf of accused 15 and 16, those entities, they plead in terms of section 1061F that this court lacks jurisdiction.
Well, that covers everybody, isn't it?
Yes, Your Lordship.
Yes.
Count 12, unlawful possession of ammunition, contravening Section 33, reduce Sections 1, Sections 38, subsection 2, Section 39 of the Arms and Ammunition Act of 1996, as amended in respect of accused 10. In that, upon about 14 December 2019, at or near Windhoek, in the district of Windhoek, the accused did wrongfully and lawfully possess rounds of ammunition without being in lawful possession. Apologies. Possess 9mm rounds of ammunition without being in lawful possession of an arm capable of firing that ammunition.
Yes. You understand the judge?
I understand the charge, my lord.
Yes. And how do you plead to it?
My lord, I'm legally represented. As I said, mentioned yesterday, my legal representative informed this court that it's not available. The fact that it's not available, I'm unable to plead.
Yes, I enter a plea of not guilty.
As it please the court. Count 13 is a charge of defeating or obstructing or attempting to defeat or obstruct the course of justice. This is in respect of accused persons number 3 and 10, Your Lordship.
Yes.
Does the court prefer me to read?
You said you read the charge. If it is brief, you read the whole of it. If it is long, you probably leave the particulars.
As it please the court.
But at least the charge.
As it please the court, Your Lordship.
I mean, the charge is simply defeating or obstructing or attempting to defeat or obstruct the course of justice.
Yes, Your Lordship, that is the charge in respect of accused 3 and 10.
This is a common law offense.
Yes, Your Lordship.
Yes, accused number 3.
Yes, Judge, I have read the charge. I understand it. I find it totally absurd. It says that the court has no jurisdiction in terms of 1061F.
Yes, I've entered a plea of not guilty.
I understand the charge, my lord. I'm unable to plead due to the fact that my legal representative is not available or it's not here today.
Yes, I enter a plea of not guilty.
As it please the court. Count 14 is a charge of assaulting, resisting, or obstructing an authorized officer in contravention of Section 29(1)A, reduce Sections 1, 3, 22 to 28, 29, subsection 3, and 51 of the Anti-Corruption Act 8 of 2003.
Yes.
I understand the charge, my lord. I'm unable to plead to the fact my legal representative is not here.
Okay, you confirmed. Okay.
You confirmed what? That you have read or you understand?
And I understand,
Yeah.
my lord. Correct.
Yes, not guilty plea is entered.
As it please the court. The first alternative to count 14, it's a charge of contravening Section 35, subsection 1, reduce Sections 1 and 13 of the Police Act of 1990, assault on a member of the police. This is in respect of accused 10.
Yes?
My Lord, I read it and I understand it. My legal representative is not available. I'm unable to play.
I hope it is clear to you that the reason I enter a plea of not guilty is that you say, because my lawyer is not here, I am unable to plead. I construe that to mean I am not tendering a plea. And that is why I enter a plea of not guilty. Yes, so the not guilty plea is entered.
As it plays the court, second alternative to count 14, it's a charge of contravening section 35, subsection 2A, read with sections 1, 13, 14, 15, 16, and 35, subsection 2 of the Police Act, 19 of 1990, resisting a member of the police in respect of accused 10.
Yes.
I plead the charge, my Lord. I understand it. I'm unable to plead the fact that my legal representative is not present.
Yes, I enter a plea of not guilty.
As it plays the court, count 15, that the accused are guilty of the crime of contravening section 43, subsection 1, read with sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and further is read with the provisions of sections 94, 155, and 156 of the Criminal Procedure Act 51 of 1977, corruptly use his position or position in a public body to obtain any gratification for the benefit of himself or accused 2. This is in respect of accused 3 and 4, Your Lordship.
Yes, Mr. Shanghala.
Judge, I have read this charge. I understand it. I can say lots of things about it, but I will not. I plea that this court does not have jurisdiction under section 106(1)(f).
Yes. Mr. Esau.
Judge, I have read this very count 15. I've tried to internalize the allegations or the charge, and in the absence, again, of a legal representative, I plead not guilty to this very charge.
Yes, I enter a plea of not guilty.
As it plays the court, count 16. May I just also highlight, in respect of this count, Your Lordship, that this is the count where an application was made to amend page 89, where this first was replaced with 7th, just for the accused's attention.
Sorry, where was the amendment? On page?
Page 89, Your Lordship.
89.
Yes, Your Lordship.
As in the view, discuss the amendment.
Excuse me, Your Lordship.
Have you discussed the amendment?
We've not discussed it with the accused persons. As I submitted.
So I just want to know whether there's any objection to that amendment.
Yes, Your Lordship.
Any of accused 2 and 4, there is an amendment at page 89. That amendment, as you remember, it was to say that at the top there, the second line, instead of first accused, it refers to 7th accused. Do you have any objection to that amendment?
Not at the moment.
Yes.
As it plays the court.
And sorry, the other accused is number 4. Do you have any objection to that amendment?
Excuse me, my lord.
Do you object to the amendment at page 89?
Well, I do take note of the amendment. I don't have any objection as it was put by the state.
Yes. Yes.
Count 16, that the accused are guilty of the crime of contravening section 43 subsection 1, read with sections 32, 43 subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and further has read with the provisions of sections 94, 155, 156 of the Criminal Procedure Act 51 of 1977, corruptly used his office or position in a public body to obtain gratification for the benefit of himself or accused 7 in respect of the 2nd and 4th accused.
Registrar, can I have that document with the list of accused, where the accused persons are listed, please? Do you have any document with you there? Yes. Thanks. Yes, Mr. Hatuikulipi?
Yes, I've read the count 16 and I plea in terms of section 1061F.
You understand it?
I understand it. I plea in terms of section 1061F of the CPA 1977 that the court has got no jurisdiction.
Yes, I enter a plea of not guilty. Mr. Esau?
On this very count, my lord, I've tried to read it to understand how I was using my office for any gratification of myself or for accused 7. But I can't comprehend that, but maybe it will come out when we are in the trial. And I am pleading not guilty. Notwithstanding the fact that I am not legally represented.
Yes, the not guilty plea is entered. Yes.
As it plays the court, count 17, that the accused are guilty of the crime of contravening section 43, subsection 1, read with sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and further is read with the provisions of Section 94, 155, and 156 of the Criminal Procedure Act 51 of 1977, corruptly uses position, office or position in a public body to obtain any gratification for the benefit of himself or accused 2. This is in respect of accused 2, 3, 4, and 7, Your Lordship.
Yes.
I've read the count 17. I understand it. I plea in terms of section 106, 1F, the CPA, that court has no jurisdiction.
Yes, I enter a plea of not guilty.
Yes, Judge, I've read that charge 17. I understand it. I plea that the court lacks jurisdiction under section 106(1)(f of the CPA.
Yes, I enter a plea of not guilty.
Accused 4 have read this very count 17 in terms of the charge I'm faced with of obtaining gratification for myself or for accused 2. And my understanding of this very charge against me as a layman, I plead not guilty, my lord.
Yes, a not guilty plea is entered.
Yes,
Yes, Mr.
Nghipunya.
Nghipunya. You rarely rise, so. I'm saying you rarely rise, so sometimes I miss you.
Yeah, no, I'm still here.
You have to. Let's proceed.
Your Lordship, I understand the charge, and I'm pleading not guilty.
Yes, not guilty plea entered. Yes.
As it please the court, Your Lordship. Count 18. That the accused are guilty of the crime of contravening section 46B, read with sections 32, 43, subsection 2, 43, subsection 3, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and further has read with sections 94, 155, 156 of the Criminal Procedure Act 51 of 1977, conspiring with each other to commit an offense of contravening section 43, subsection 1, read with sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and count 15. This is in respect of accused 2, 3, 4, 5, 6, 12, 13, 15, and accused 22 to 24, Your Lordship.
Yes. Yes, Mr. James Hatuikulipi.
I've read count 18. As per the indictment, I understand it. In respect of myself and accused 22, we plea in terms of section 106(1)(f) of the CPA 77 that the court has no jurisdiction.
Yes, a not guilty plea is entered. Yes, Mr. Shanghala.
Yes, I have read the count 18. I understand it. On behalf of myself and accused 21, enter the plea of lack of jurisdiction under section 106(1)(f) of the CPA.
Yes, not guilty plea entered. Yes, Mr. Esau.
On count 18, that is accused 4, I plead not guilty. On accused 24, I was not even given authority in writing, neither through a round robin or otherwise, to plea for 24, because we are more than one members.
Yes.
Maybe if I can just briefly address the court on that issue that is raised in respect of the 24th accused person, Your Lordship. First and foremost, in these proceedings, throughout, the 24th accused person has been represented by the accused person before court. Even the legal practitioner who used to appear before court here confirmed appearance for both accused persons during remands. Now, this issue that he has raised with regard to the absence of resolutions.
Sorry, just a minute.
Yes,
Accused number 24 has always been represented by who?
Mr. Biekes. Mr. Biekes has been appearing for both Mr. Esau and accused 24, and as already indicated earlier on, Mr. Esau has also been representing accused 24 in these proceedings. Your Lordship, on the issue that...
But that is the point. Mr. Biekes was representing accused number 24.
Yes.
And representing Mr. Esau.
Yes.
And you are saying Mr. Esau has also represented accused number 24.
In his capacity as a member of the accused person, was here in his capacity, cited both in his personal capacity and his capacity as a member of the...
He's charged?
Yes.
In his representative capacity?
The company, he's appearing for the company, yes, Your Lordship. I just want to highlight one thing on what he says, that he does not have a resolution. Your Lordship, if the court has regard to section 332 of the Criminal Procedure Act, that is the provision that deals with companies and how they should be charged. I'll just read it out.
Is that section what?
332, subsection 2.
32(2).
Yes, Your Lordship.
Yes.
I'll just read it out, just for clarity's sake.
Can you read it loud so that you can hear?
I'll read it out loud, Your Lordship. It is titled Prosecution of Corporations and Members of Associations, Section 332, subsection 2. In any prosecution against a corporate body, a director or servant of that corporate body shall be cited as a representative of that corporate body as the offender, and thereupon the person so cited may, as such representative, be dealt with as if he were the person accused of having committed the offense in question. provided that, and this is subsection A, if the person pleads guilty, if the said person pleads guilty, other than by way of admitting guilt under section 57, the plea shall not be valid unless the corporate body authorized him to plead guilty. So what is required here, Your Lordship, is if the person intends to tender a plea of guilty, then certainly you need a resolution. But when it comes to charging the corporate entity, what is required and is mandatory that the directors or servants shall be cited. And that is what has happened in this particular case. Mr. Esau was cited in this particular case as a representative of that company, that entity. So there's no need for a resolution insofar as that is concerned. This is one of the exceptions with regard to resolutions needed in order to represent an entity, Your Lordship, as provided for in the Criminal Procedure Act.
You are saying he has no option in the matter.
Excuse me, Your Lordship?
You are saying he has no option in the matter.
No, he has no option. He has
He's
to...
charged in his representative capacity.
Yes, Your Lordship.
He's charged.
Yes.
And the section says he shall, for all purposes, he shall be
dealt with as if he were the person accused of having committed the offense in question.
Yes.
So it's mandatory. He must deal with the pleas. If he does not wish to deal with the pleas, then he must inform the court. If he does not wish to tender a plea on behalf of the entity.
That's what he has said.
Yes, then it's for the court to enter a plea of not guilty. So it's for the court now to exercise its powers if he's refusing to plea on behalf of that entity, Your Lordship. That is all for the state submissions.
All right, Mr. Esau. You understand what they have said in relation to section 332, subsection 2 of the CPA Act, that because a company is a fictitious legal entity, when it is charged with a criminal offense, one of its officers, director or MD, is the one who must stand for it. In fact, he is the one charged, and he must answer for it. And the only exception is where, for instance, you want to plead guilty because it's known to be a separate entity. If you plead guilty, then that company is required to file a resolution accepting that plea of guilty. Other than that, the state is entitled to charge an officer of the court, a director, whoever they have properly picked upon to charge, so that the company doesn't talk. It talks through its directors and so on. So, according to the state, you are obliged to represent accused number 24.
Yeah, no, thank you very much, Your Lordship, for trying to explain to me the...
Is there someone else in accused number 24 who you think should have been charged to represent the the corporate body?
My Lord, that question has to be determined by the court. I cannot pinpoint.
No, you see, the court doesn't choose who to charge. This court didn't even choose to charge any of you. Someone else chooses to charge. And here the state has chosen to charge Mr. Esau to represent accused number 24. And according to that quick reading of 332 subsection 2, Mr. Esau has no option unless he can come to court and say, you know what, I'm not really the effective person in that. Please charge X. He's the alter ego of the company. But short of that, they have said, I assume, I don't know what representative capacity you have in relation to accused number 24. But the state has said, we are charging you on behalf of your entity, accused number 24. And you have no option in that except to act for it in these criminal proceedings.
Let the court place a plea in on behalf of that entity.
What do you mean, let the court? This court doesn't just place a plea. It places a plea, either the person who must plead refuses to do it. If he refuses, I enter a plea of not guilty. If he tenders a plea, I tender his plea.
I refuse, my lord.
Yes.
In the absence of a resolution or anything.
I will enter a plea of not guilty in respect of accused number 24, having Mr. Esau having refused to plead on his behalf, and in respect of himself, as he said, the plea is one of not guilty.
Yes, my lord. I understand the charge. Pleading not guilty on behalf of my entities, 12 and 13.
12 and 13. Yes, I enter a plea of not guilty. Mr. Mwatelulo.
I understand the charge. I've read it. I plea in terms of section 106(1)(f) that this court lacks jurisdiction, and the plea stands for accused 15.
Yes, a plea of not guilty is entered. Yes.
Yes, Your Lordship. I'm representing accused number 23 in that count.
That's Mr.
Otneel.
Sorry?
Otneel Shuudifonya.
Oh, Shuudifonya.
Accused number 8.
I prefer using the names rather than writing accused. I prefer saying Shuudifonya. Others prefer to use accused. Right, so you are
I'm accused 8, representing accused 23 in count 18.
Yes.
I've read the charges, I understand it, and I plead not guilty on behalf of accused 23.
Yes. So the not guilty plea is entered.
As it plays the court, in respect of count 19, that the accused are guilty of the crime of contravening section 46 sub B, read with sections 32, 43 subsection 2, 43 subsection 3, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and further has read with the provisions of sections 94, 155, and 156 of the Criminal Procedure Act 51 of 1977. conspiring with accused 2 and 4 to commit an offense of contravening section 43, subsection 1, read with sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003 under count 16. This is in respect of accused number 2, 3, 4, 5, 6, 7, 12, 13, 15, 22 to 24, Your Lordship.
Yes. Accused number 2. Mr. Hatuikulipi, is it? Count number 19.
Yes. In terms of, in respect of myself and accused 22, we plead in terms of section 106(1)(f of the CPA, 1977, that the court has no jurisdiction.
Yes.
Judge, I've read the charge. I understand it, and I plea in terms of section 106(1)(f that the court lacks jurisdiction.
Yes, the plea of not guilty is entered. Yes.
Count 19, my lord, as accused 4, notwithstanding the fact that I don't have legal representation, or representative in fact, I plead not guilty. On the entity 24, the status remains as count 18. I cannot plead because I don't have any authority, I don't have any mandate in terms of a resolution written in the pleading process. This pleading process. So court can enter the plea.
Which one?
The one like 20, count 18.
You refuse to plead for?
Yes, my lord. Otherwise, I might be taken again to prison for pleading without any authority.
I enter a plea of not guilty for accused number 24. Yes, James.
My lord, I understand the charge.
Tamson.
I'm pleading not guilty on behalf of my entities, 12 and 13.
Yes, that plea is of not guilty is entered.
I understand the charge, Judge. And on behalf of myself and accused 15, I plea in terms of section 106(1)(f that this court has no jurisdiction.
Yes, the not guilty plea is entered.
Yes, Your Lordship, I understand the charge, and I'm pleading not guilty.
There's no entity associated with you here?
No, not in that charge.
Yes. Is everyone covered?
Accused 23.
Your Lordship, I don't think I'm in that count. Accused 23 is not there. It says 22 and 24.
Yes, indeed, Your Lordship. My apologies. Count 20, that the accused are guilty of the crime of contravening Section 46, subsection B, read with sections 32, 43, subsection 2, 43, subsection 3, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and further is read with the provisions of sections 94, 155, and 156 of the Criminal Procedure Act 51 of 1977. Conspiring with accused 1, 2, 3, and 4 to commit an offense of contravening section 43, subsection 1, read with sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, under count 17. This is in respect of accused persons number 2, 3, 4, 5, 6, and 80, and 12, 13, 15, 22, and 24.
Yes. Mr. Hatuikulipi.
Yes, I've read count 20, I understand it. In respect of myself and accused 22, we plea in terms of section 106(1)(f), the CPA, lack of jurisdiction.
Yes, I've entered a plea of not guilt for the 2.
Judge, I've read the charge. I understand it. And I enter the plea provided under section 106(1)(f) of the CPA.
There's no entity involved here.
Well, it reads and.
Sorry?
It reads only and, not 22 to 24. So.
No, I'm just for clarity. That's all.
No, not at all. So.
Yes, I enter a plea of not guilty.
20, I have read this very charge. I do understand it. And as accused 4, I plead not guilty in the absence of a legal representative. On the entity.
Do you think your legal representative will come and say, you should have pleaded guilty?
Maybe he might say, I don't know, my lord.
Yeah, all right.
I don't know what he will, if I happen to get one.
All right. No, you'll have the opportunity to look for one. As I said before, when we are at Jen, and even if we resume in February, if another month and more, to look for your lawyers to do what you must do.
During Christmas.
Yes. That's all right, but the opportunity to look for lawyers is here with us. It's there today. It will be there for another month or more before we start.
If the lawyers are in solidarity, my lord.
They're in solidarity with?
With me, with my cause.
Oh, I see.
My lord,
I understand there's no contingency funding here, contingency funding, eh? In other places, a lawyer will go into a contingency arrangement where he says, oh, I'm very certain you will succeed, and when you succeed, you pay me. And he works, and then he's paid after a successful outcome.
The state must take care of that, my lord. But on 24, accused 24, the state has remained as 19 and 18. Count 18 and 19.
Yeah, for you it's a not guilty plea. For accused 24 is also a not guilty plea which I enter.
Yes, my lord. I understand the charge. I'm pleading not guilty. And on behalf of my entities, 12 and 13.
Yes, I enter a plea of not guilty.
Yes, Judge, I understand the charge. And I plea in terms of section 106, 1F, that this court has no jurisdiction, and the plea stands for accused 15.
Yes, Your Lordship, I understand the charge and I'm pleading not guilty. I don't have an entity there.
Yes, not guilty plea is entered.
As it pleases the court. Your Lordship, count 21 is with regard to accused 7. There was also an application for an amendment in respect of that count at page 98. Okay. No, my apologies. We will still get to that one. It's count 22 where the amendment was sought. Count 21, that the accused are guilty of the crime of contravening section 43, subsection 1, read with sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003. And further has read with the provisions of sections 94, 155, 156 of the Criminal Procedure Act 51 of 1977, corruptly used his office or position in a public body to obtain any gratification for the benefit of himself, or accused 8, 9, 23, and 25 to 28. This is in respect of accused 7.
Yes, Mr. Nghipunya.
Yes, Judge, I understand the charge and I'm pleading not guilty.
Yes, not guilty plea is entered.
As it pleases the court. With regard to count 22, an amendment or an application for amendment at page 98.
Yes, you noted the amendment, did you? This count relates to
With regard to accused 7, 8, 9, 23, and 25 to 28.
Yes. As concerned, if you, when you stand up, please can you advise whether you object to the amendment? If you don't, and then tender your plea. As you are starting with the accused number 7, Mr. Nghipunya, isn't it? For you and what?
I'm understanding the judge to say I should say if I have an objection to the amendment and tender my plea.
Yeah, because we have to deal with the amendment first.
Yeah, okay.
If you have an objection to it, then we deal with the objection.
I have an objection to the amendment, Judge.
Yes. Yes, so you have read and understand the charge?
I read the charge and I understand it, and I'm pleading not guilty. And in terms of, not in terms, but on behalf of 25, I'm pleading not guilty as well.
Yeah, so a not guilty plea is entered in respect of yourself and the accused number 25. Yes, Mr. Shuudifonya.
Yes, Your Lordship. I'm accused number 8.
Yes.
And I'm representing 23, 27, and 28. So I have no objection with the amendment. And I read the charge and we plead not guilty.
You understand it?
Yeah.
Yes, a not guilty plea is entered for you and the entities you represent. That's accused number 9, is it? Mr. Mwapopi. Is that so?
I understand the charge.
Yes.
Both myself and accused 26 not guilty.
Yes, I enter a plea of not guilty for both of you.
As it pleases the court. Count 23. That the accused are guilty of the crime of contravening section 43, subsection 1, radio sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003. And further is read the provisions of sections 94, 155, 156 of the Criminal Procedure Act 51 of 1977, corruptly use their offices or positions in a public body to obtain any gratification for the benefits of themselves, and accused 9 and 26 or any other person. This is in respect of accused 2 and 7, Your Lordship.
Yes. Yes, Mr. Hatuikulipi.
I've read the count, 23. understand it. And I plead in terms of section 106, 1F of the CPA, that the court is no jurisdiction.
Your entities are what? Is there any entity involved with you here? Any entity involved with you?
No.
No, okay. Yes, not guilty, please entered.
Yes, Your Lordship, I understand the judge and I'm pleading not guilty.
Sorry. Yes. You said I understand the charge and plead not guilty.
Yes, that's correct.
Yes.
As it pleases the court. Count 24. That the accused are guilty of the crime of contravening section 46, subsection B, read with sections 32, 43, subsection 2, 43, subsection 3, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and further is read with the provisions of sections 94, 155, 156 of the Criminal Procedure Act 51 of 1977. That is conspiring with each other to commit an offense of contravening section 43, subsection 1, read with sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003 under count 23. This is in respect of accused 2, 7, 9, and 26, Your Lordship.
Yes. Mr. Hatuikulipi.
In respect of myself, I plead in terms of section 106, 1F, the CPA 77, court is not jurisdiction.
The charge you understand?
I understand the charge, yes. No entity.
Yes, I enter a plea of not guilty.
Yes, Your Lordship, I understand the charge and I'm pleading not guilty. I have no entity in this charge.
Yes?
I'm pleading not guilty and I have no entity in the charge.
Yes. Yes, I enter a plea of not guilty. Accused number 9 is, no, is it? Yes?
I understand the charge, myself and the entity not guilty.
Yes. I enter the plea stated.
As it pleases the court, Your Lordship, we stand to be guided by the court. It's 10 to 1. Should we break for lunch or does the court prefer we proceed? At this pace, I suppose we might finish today, even if we sit at 5, we can. It depends.
Is that to urge me to have an early break? So, right. So what time do we resume? Yes?
Sorry, Judge. I was of the opinion that it's 10 to 1. We can just nail the 10 minutes.
Sorry?
I was of the view that it's 10 to 1. We can just nail the 10 minutes quick.
We are at account number 24. We have just done 24. We have another, how many more? Maybe another 20. So I'm quite happy to follow you this time. Let's carry on until 1 o'clock.
please the court, Your Lordship. In respect of count 25, that the accused is guilty of the crime of contravening section 43, subsection 1, reduce sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, read the provisions of sections 94, 155, and 156 of the Criminal Procedure Act 51 of 1977, corruptly used his position, his office or position in a public body to obtain any gratification for the benefit of himself or accused 8, 23, 25, 27, and 28. This is in respect of accused 7.
Yes, Mr. Nghipunya.
Your Lordship, I understand the charge and I'm pleading not guilty.
Yes, a plea of not guilty is entered.
As it pleases the court, in respect of count 26, Your Lordship, there was also an application to amend. Where it reads conspiring with accused 1 and 2, that to have been replaced with 7 to commit an offense.
Yes.
And where it reads in respect of accused 2, 7, 8.
You deleted 2 and 7.
Yes, Your Lordship.
So it's 8, 23, 25, 27 to 28.
Yes, Your Lordship.
Yes.
Count 26, that the accused are guilty of the crime of contravening section 46B, read with sections 32, 43, subsection 2, 43, subsection 3, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, and further is read with sections 94 of the Criminal Procedure Act 51 of 1977, conspiring with accused 7 to commit an offense of contravening section 43, subsection 1, read with sections 32, 43, subsection 2, 46, 49, and 51 of the Anti-Corruption Act 8 of 2003, under count 25. This is in respect of accused persons number 8, 23, 25, and 27, 28.
Yes, you have noted the amendments there, isn't it?
Yes, I did, my lord. And I have no objection. So I'm accused 8, representing accused 23, 27, and 28. I read the charge.
Just a minute. As accused.
I'm 8.
Yes.
Representing 23, 27, and 28.
Yes.
I read the charge, understand it, and I plead not guilty.
You plead?
Not guilty.
Okay. Yes.
Your Lordship, I'm representing accused 25. I understand the charge. I have no objection to the amendment, and I'm pleading not guilty.
That's for accused 25.
25, yes.
Yes.
As it plays the court, count 27. That the accused are guilty of the crime of fraud has read with the provisions of section 94, 155, 156, and 332, subsection 5 of the Criminal Procedure Act 51 of 1977 as amended in respect of accused 2 to 7, 12, 13, 15, 22, and 24.
Yes, Mr. Hatuikulipi.
Yes, I've read the count 27. And in respect of myself, the accused 22, we plead in terms of section 106(1)(f), the CPA, court has no jurisdiction.
Yes, I end a plea of not guilty. Yes.
Yes, Judge, I have also read it. I understand it. And I think this is, yeah, this is the one. Yes, I plead that the court lacks jurisdiction under section 106(1)(f) of the CPA.
Yes, a not guilty plea is entered. Yes, Mr. Esau.
Thank you very much, Your Lordship. On count 27, I have read this very count, which relates to executive functions, which was never challenged as well. But I'm pleading not guilty. As accused 4. And secondly, on the entity, I was not given the necessary authority in terms of a resolution to plead guilty or not guilty. Hence, I am leaving it in the hands of the Lord.
The mandate you wanted is only if you are pleading guilty. If you are not pleading guilty, you don't need any mandate there.
On both sides.
Anyway, I understand your position. A not guilty plea is entered for both yourself and accused number 24. Yes.
My Lord, I understand the charge. I'm pleading not guilty, and on behalf of my entities, 12 and 13.
Yes, a not guilty plea is entered.
Yes, Judge, I understand the charge. And in respect of myself and accused 15, I plead in terms of section 106(1)(f) that this court does not have jurisdiction.
Yes, a not guilty plea is entered.
Yes, Your Lordship, I understand the judge and I'm pleading not guilty.
That's Mr. Nghipunya, isn't it?
Yes.
Yes.
Judge,
Yeah, no, I heard, but I was just verifying the name.
Yes, okay.
Yes. I have entered a not guilty plea. Anyone outstanding? on this count number 27.
No, Your Lordship.
All right.
Perhaps it's an opportune time.
Is it 1 o'clock?
Excuse me, Your Lordship?
Is it 1 yet? Is it 1 o'clock yet?
Yes, it is after 1. I think it's even a minute past.
No, let's finish off the alternative to count 27.
As it pleases the court, Your Lordship. Alternative to count 27, that the accused are guilty of the crime of theft has read with sections 94, 155, 156, and 332, subsection 5 of the Criminal Procedure Act 51 of 1977, in respect of the same accused person as mentioned in the main count, Your Lordship.
Yes. Mr. Hatuikulipi?
Yes, I've understood the charge in respect of myself and accused 22. We plea in terms of section 1061F of the CPA that the court is not jurisdiction.
Yes, a not guilty plea is entered.
Yes, I've read the charge. I understand it. I plead that the court lacks jurisdiction under section 1061F of the CPA.
Yes. Yes, Mr. Esau.
On the alternative count, to 2027, as accused 4, I plead not guilty. And for the entity, the status quo remains.
Yes, I enter a plea of not guilty for both.
Yes, my lord, understand the charge. I'm pleading not guilty on behalf of my entities, 12 and 13.
Yes.
Yes, Judge, I understand the alternative count. In respect of myself and accused 15, I plead in terms of section 106, 1F of the CPA, and that is to say this court does not have jurisdiction.
Yes, I end a plea of not guilty.
Yes, Your Lordship, I understand the alternative charge count and I'm pleading not guilty.
That covers everybody on that charge.
Yes, Your Lordship.
But we'll continue after lunch with the count number 28, is it?
Yes, Your Lordship.
What time after lunch?
Stay request for 2:15, Your Lordship.
Is that suitable for everybody? 2:15?
The judge.
Yes. The court will adjourn to 2:15.